So friends, the Michigan State Supreme Court just refused to hear a case regarding whether Donald Trump's name should be banned from the Republican primary ballot in the state of Michigan. But hold on, because even in the Michigan state courts, this one is far from over. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. Friends, it's good to be back with you. I've been away for a few days. I took a little bit of downtime to re-energize, recharge my batteries. I know I look a little scruffy. I haven't even shaved yet. Shh, don't tell anybody. But I really wanted to take just a little bit of time away to gear up for what will be the 2024 Justice Sprint. I know I should call it a justice marathon because we're going to spend the next 10 months sort of running flat out in the direction of accountability, through Trump trial after Trump trial to the inevitable first Donald Trump criminal conviction, and then we will keep running straight to November 2024, where, it's all on the line for American democracy. So I hope you will pull on your justice shoes, warm up. You don't want to pull a hamstring, stretch. And I know you will be running right there with me as we take on every legal issue of the day over the course of the next 10 months as we head in the direction of accountability. So let's take on this brand new reporting involving the Michigan State Supreme Court, because we just learned that the Michigan Supreme Court refused to hear a case about whether former president and current insurrectionist Donald Trump should be barred, should be banned from having his name placed on the Republican primary ballot in the state of Michigan. And please put a pin in that word, primary ballot. We're going to come back to it. But when I read the reporting this morning, it felt wrong, right? It felt like a bad decision. It feels like common sense in America is dying a death of 1,000 cuts. But when we dig into the Michigan case, as we're going to do in a few minutes, we're going to see that it ain't over. It ain't over in the courts of Michigan, not by a long shot. But let's start, as always, with the new reporting. This article is from the Detroit Free Press by a local reporter named Paul Egan, and I have to say, the local reporters, the local newspapers around the country have been doing such great work, particularly on the issues as they arise in their states. I was a journalism major undergrad, and I'm a bit of a frustrated journalist myself, so I so admire the reporting that the local media, the local newspapers have been doing. So as I say, this is from the Detroit Free Press. Here's the headline: Michigan Supreme Court keeps Trump on ballot, rejects insurrectionist argument. And that article begins, the Michigan Supreme Court has declined to hear a case arguing that former President Donald Trump should be excluded from the state's primary ballot, meaning the frontrunner for the GOP nomination will remain a listed candidate. The order issued Wednesday is in line with lower court rulings in Michigan, though at odds with a recent ruling by the Colorado Supreme Court. The argument over whether Trump is an eligible candidate for president centers on whether his conduct related to the January 6, 2021 riot at the U.S. Capitol should be considered engaging in insurrection. The 14th Amendment to the U.S. Constitution bars anyone who has taken an oath to uphold the Constitution to hold office if they have engaged in insurrection or rebellion against the U.S. Another central issue in a spate of court cases is whether it would be within state powers or only the power of Congress to bar a candidate over such an issue. In a Wednesday order, Michigan's highest state court said, "It is not persuaded that the present questions should be reviewed by this court." It refused to reconsider a mid-December decision by a three-judge state court of appeals panel. That ruling affirmed a lower court ruling that neither the courts nor Secretary of State Jocelyn Benson can bar Trump from being a candidate in Michigan's February 27 Republican primary. Mark Brewer, the lawyer for Michigan voters seeking to exclude Trump from the ballot, and a former chairman of the Michigan Democratic Party, called the decision very disappointing but extremely narrow. If Trump becomes the Republican nominee, that is, in the general election on the general presidential ballot, if Trump becomes the Republican nominee, his clients will again challenge his eligibility for the general election ballot in November, he said. And friends, here's the key. It has to do with the Michigan state law regarding elections and who can and who can't be on primary ballots. Under the wording of the Michigan state law, the Secretary of State does not have the authority to exclude from the ballot a prominent candidate, such as Trump, whose name has been put forward by a political party regardless of whether he is ineligible under the U.S. Constitution. Friends, let me say that again. The state law in Michigan says that the Secretary of State has no authority to keep somebody's name off the ballot if the Republican Party put that name forward. In other words, the Republican Party could forward somebody who was younger than 35 years of age, such that that person would be disqualified from serving as president. Doesn't matter. Under the laws of Michigan, the Secretary of State can't keep that name off the Republican primary ballot. Heck, the Democrats in Michigan could put Barack Obama's name forward to be included on the Democrat primary ballot, and the Secretary of State would have to include Barack Obama's name, even though he is not eligible to serve a third term. He's already served 2 terms as president. That is the way the Michigan state law is drafted. So friends, an important lesson. Some state election laws and procedures are drafted well, others are drafted less well. So let's look to the laws of Colorado. Recall there was a trial in the courts of Colorado, and after a trial at which many witnesses testified and the judge made factual findings, the court concluded Donald Trump engaged in an insurrection. That case went up to the Colorado Supreme Court, and under the laws and procedures in Colorado, the Supreme Court ruled, yeah, Donald Trump is barred, banned, prohibited from having his name put on the primary ballot in Colorado. That was in keeping with the state election laws of Colorado. Some state election laws and procedures are drafted less well, I suggest, like Michigan. Because, friends, does it make any sense that the Republican Party can insist that a candidate who is entirely disqualified from serving in public office because he engaged in insurrection, or he is not yet 35 years old, or he is not a natural-born citizen, right? These are the disqualifiers in the Constitution, no wiggle room there. And yet, in Michigan, the state election laws and procedures and rules say it's just fine for the Republican Party, or for the Democrats for that matter, to put a disqualified candidate on their primary ballot. The Secretary of State can't say no, can't refuse to include that name. That doesn't make a lot of sense to me, so I would suggest the Michigan election laws and procedures are drafted less well. But importantly, all the Supreme Court of Michigan said right now is that we're not going to take up the issue of whether a disqualified candidate, whether Donald Trump can have his name on the Republican primary ballot, because the Secretary of State has no authority to keep that person's name off. So at this point, there is no legal issue to be decided. There is a doctrine in the law actually called ripeness, right? Legal issues, like fruit, have to be ripe. You're not eating fruit if it's not ripe, and courts aren't deciding legal issues if they're not ripe. Literally, we call that the legal doctrine of ripeness. So this issue is not yet ripe because an insurrectionist's name or a 12-year-old's name can be placed on the Republican primary ballot if the Republican Party in Michigan decides it wants that name on the ballot. And the Secretary of State can't say no. However, if somebody who is constitutionally disqualified from serving as president, from holding public office in the future, wins the primary and becomes the Republican nominee and wants to have his name put on the general ballot in Michigan, I would contend that the issue will then be ripe. And unlike what just happened, the Supreme Court in Michigan saying, nope, we're not accepting the case, we're not going to review it, well, at that point, I think the case will have to be reviewed. Why? Because the Constitution prohibits Donald Trump, an insurrectionist, from serving as president. So at that point, I suspect we will see additional litigation in Michigan. And you don't have to take my word for it. The litigants who brought this case that the Supreme Court just said in Michigan it was unwilling to review said the following, returning to the Detroit Free Press article: if Trump becomes the Republican nominee, they will again challenge his eligibility for the general election ballot in November. Why? Because justice matters. It's good to be back, friends. As always, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.